What will be your submission with regard to paying 20 or 25,000 rupees to a whole lot of candidates who are sitting at home and not doing any work? Public, you are spending public money for it.
Can the state, in any form, giving in the name of relief, support corruption? Supreme Court that they have to return the benefit of money which they have earned so long. And instead of getting the money returned from them, you are trying to support them out of public fund.
Yes.
So that before he starts, I have taken his kind leave. But may I place? So thereafter, two further applications are moved to the Supreme Court.
All right.
Now, I kindly takes up this the application, the prayer which was made, not by the state but by the affecting parties.
কোন অর্ডারগুলো দেখাচ্ছে?
না ওটা দেখাচ্ছি তুমি
স্যার এই অর্ডারটা দেখাচ্ছি।
Is it in the same appeal?
Same.
All right.
After the judgment was delivered on 3rd April,
Yes.
17th April, the state application where the modification was to the extent that teachers may be allowed till 31st December who are not tainted. Thereafter, another application was filed by some of the candidates who lost their job.
Right.
This was the prayer made and the order was passed by this court. কি ব্যাপার ওটাকে দিয়ে চোখে দাও না
Clarify.
কি নিয়ে পড়তে পারি
আরেকটা
on 23rd of May
All right.
the Honorable Court passes the order dismissing the application. We find no ground and reasons to entertain these applications purportedly filed for clarification of the judgment and order dated so and so. Any connected matters.
All right.
There before, without notice to us, this was notice to us, another application was moved. There also the Honorable Court passed this order. একই order.
23/5 দুটো কি 23/5
21 ওই একটা ওই মীনাক্ষী অর্ডার করলো একটা বকুল ভারতী
One is on 21st May, one is on the 23rd of May.
Yes. Of different group of
And
different
prayer was same for permission to file additional
Yes.
documents, facts, clarification, direction for grant of interim relief, permission to file additional documents. All right.
Therefore, the repeated attempt was made before the Honorable Supreme Court. Honorable Supreme Court did not at all entertain these prayers. In that background, this
Scheme has been formulated. All right.
Milord, first is, Milord, who are before the court. Milord, please have a look to me at paragraph 2 of the writ petition. Two, 3 and 4. The petitioners state that your petitioners have the requisite qualification for being appointed in Group C and Group D post in any so and so. Then para 3, your petitioner states that the commission published an advertisement for appointment in the post of Group CD. Pursuant to the advertisement, petition number 1 applied for Group C and petition number 2 Group D, and the petitioners participated. Then para 4, the petitioner states that the petitioners were placed in the waiting list. This is very important. And soon thereafter, the petitioner found that there was large scale, etc. First is, Milord, the petitioners, Milord, were not appointed. They were, Milord, waitlisted candidates. Therefore, Milord, any scheme framed for those who have lost their job, Milord, in my very respectful submission, cannot in any way, Milord, prejudice the rights of the petitioners. Because we are before a mandamus court, we are not before, Milord, any public interest litigation court. Milord, this is my first respectful submission. But the second submission is, Milord, the waitlisted candidates were also before the Supreme Court. Milord, your Lordship may kindly, Milord, have a look to me at page 29, the relevant portion of the Supreme Court's order. This is the 5th page, Milord, of the Supreme Court's order. Please check the last 3 lines. Other writ petitions were filed subsequently in 2021, seeking individual appointments and alleging illegalities in the 2016 recruitment process. Illustratively, some of the issues raised were, please turn the page, clause number 4 and 6. Candidates in the waiting list for Group D post in the panel published on 26/2019 were ignored, and a new notification dated etc. has been published, initiating a new recruitment process. And 6 is, candidates neither in the merit list nor in the waiting list were appointed and also joined in the school. Then, my lord, may kindly take, my lord, the later part of the Supreme Court's order, my lord, the internal page 35 at running page 59. Para 36. Apart from so-and-so not returning mirror copies of OMR sheet, other questions arise. In particular, are the significant discrepancies between the marks in the computer software and the data found on the 3 hard disks recovered from so-and-so. Further, Commission did not upload the marks of the candidates while uploading the list of candidates called for interview and included in the panel as the wait list. Marks were only displayed after the High Court's order dated so-and-so mandated disclosure of marks. This omission appears deliberate, likely intended to conceal the marks of candidates on the wait list, raising concerns about the potential data manipulation, etc. So, the wait list candidates' concerns were also projected, canvassed, and looked into by the Supreme Court. And finally, what order has been passed is that this Honorable Court's division bench order was upheld by the Honorable Supreme Court. Therefore, my respectful submission is, number one, that the wait list candidates cannot have any grievance in respect to this scheme.
Yes.
Why? Because, please take para 45, the conclusion of the Supreme Court's order, at running page 63. But whatever, relief buffer the Supreme Court gave was all to, the candidates who got appointment on the basis of merit list, whatever was the consideration of the Supreme Court. Finally, no relief was granted to the waitlisted candidates by the Honorable Supreme Court. Please have a look at paragraph 45, 46, 47, etc. 48, 49, and finally 51, which Mr. Bhattacharjee has placed.
So the locus standi of the petitioners
is number one. Number two is, like a legislation, similarly, in case of a scheme, framing of a scheme or enactment of a legislation itself does not give rise to a cause of action for challenging the same. But the cause of action arises only when someone is affected by implementation of the act, scheme, whatever. I give you an example. Say 2003 Electricity Act is promulgated. I am aggrieved by XYZ clauses. Now, so long, I don't get aggrieved, take a cause of action. Say I get a disconnection notice in terms of section so and so of the Electricity Act. Then and then only, a cause of action would arise in my favor for moving the court. Therefore, mere framing of a scheme, mere floating of a scheme, or even legislation, does not give rise to a cause of action. A cause of action arises only when it is implemented adversely against the person concerned. So, my second point is, no cause of action has arisen for the writ petitioners to move before your lordships. But my third point is, as Mr. Bhattacharjee has placed, there are some beneficiaries under this scheme. Right or wrong, there are certain beneficiaries. None of the beneficiaries are before your lordship, or they have not been made.
Why will beneficiaries come? Because they are the beneficiaries.
No. I could not explain myself, my lord. What I respectfully submit is, my lord, none of the beneficiaries are respondents in this writ petition.
Respondents.
Yes.
All right.
Therefore, my lord, without
So you want the 25,000
no,
candidates?
they can always be, my lord, impleaded in representative capacity.
All right.
They can always be represented by representative capacity. I mean, impleaded by in representative capacity. But that prayer has not been made. That leave has also not been sought for.
Very well.
Therefore, my lord, the beneficiaries are not before the court. Number 4 is
Hmm.
where Article 144 is sought to be, my lord, invoked.
Hmm.
Where no dispute that all civil and judicial authorities must act in aid of the Supreme Court. No dispute on the proposition, because the article is explicit in that. Now, my lord, the Supreme Court has considered, because my learned friend's submission is that this scheme is to subvert the Supreme Court's direction, or whatever has been done.
Or frustrate the direction
the
of the
Supreme
court.
Court's order. Or I take it to a larger extent that it violates the Supreme Court order. But what has the Supreme Court, my lord, opined in such a situation? In such a situation, my lord, the Supreme Court has said that a writ petition is not maintainable, and judicial discipline requires that
They should approach
the Supreme Court.
State.
Just have a judgment on this, my lord. But this is a case where very short judgment, my lord, where my lord, some auction was being held, my lord, pursuant to a Supreme Court direction, my lord. A writ petition was filed, and my lord, the Supreme Court was considering whether, my lord, the High Court should have entertained the writ petition or not. Please take paragraph 4, my lord, a very short judgment. We are rather concerned to note that WP number etc. has been entertained by the Lucknow bench of the Allahabad High Court. The writ petition is directed against the auction sale of so and so, and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court noticed in the interim order that auction was being conducted under orders of the court, this court, and that the matter concerning auction of the house was pending in this court. How then a writ petition could be entertained in the High Court is not understandable. Judicial discipline requires the High Court not to entertain any such petition when the proceedings are pending in this court in respect of the subject matter of the case. The parties should have been asked to approach this court. If so advised, the High Court said had no jurisdiction to entertain the writ petition in the fact situation. We need say nothing further on this aspect except to record our displeasure. This order shall be brought to the notice of the High Court. Therefore, my lord, my next obligation is to demonstrate before this court that where the Supreme Court had passed an order, certain ancillary direction, as my learned friend has also placed, has been passed. The review application is pending before the Supreme Court, where the Supreme Court, my lord, will take a call on that, my lord, whatever is the. Now, my lord, when, my lord, the submission is that the Supreme Court's direction is sought to be subverted, or as I have said, I take it to the highest extent that it has been violated. In that case, my lord, the Supreme Court, noting, my lord, Article 144 was of the view that, my lord, it should be left to the Supreme Court, and, my lord, writ petition should not be entertained. Well, there was a development in the matter. The other development in the matter was, my lord, certain persons, but after, my lord, the order of the division bench of this court was upheld by the Supreme Court, that some persons had moved the division bench of our High Court subsequent to the order of the Supreme Court, seeking implementation of, my lord, the directions of the honorable division bench and the Supreme Court, which was ultimately, my lord, upheld by the Supreme Court. Now, my lord, there, my lord, kindly have a look to it what, my lord, our division bench had, my lord, said. This is, of course, my lord, in the contempt jurisdiction. Instead of, my lord, taking your lordship through the order in its entirety, my lord, all the judgments, my lord, on both aspects, my lord, whether to execute or not to execute, contempt, not contempt, etc., my lord, was considered. And finally, my lord, your lordship may kindly come to, my lord, paragraph 47, which is page number 26 of the judgment. This is our division bench. An order passed in the writ jurisdiction is enforced through a contempt proceeding primarily on the principle that non-adherence or non-compliance of the writ issue tends to degrade his dignity and majesty of the court issuing the writ. In the facts and circumstances of the present case, the ultimate writ was issued by the Honorable Supreme Court, and therefore contempt petition would not lie before this court to enforce such an order unless specifically empowered by the Supreme Court to do so akin to Dinesham KK Supra. Consequently, in the absence of the provisions of the Code of Civil Procedure, to execute an order passed by a writ court, the analogy or the principle that even if the ultimate decree is modified or altered and affirmed by the Supreme Court, the same needs to be executed. Then, Miller, Article 215 is considered by the Honorable Division Bench. Next, kindly take para 50 onwards, where Miller, our Division Bench, Miller, takes notes of the doctrine of merger, Miller, at paragraph 50, 51, and 52. Then paragraph 53, in the facts and circumstances of the present case, there are 3 orders of the Honorable Supreme Court. Subsequent to a judgment dated, etc., etc., Supreme Court dealt with 2 sets of appeal. Then third order is dated so and so, and a miscellaneous application filed in one of the sets of appeals before it. The last order dated 17th April of the Supreme Court contains certain directions, etc. Yeah. And Miller, the last sentence at para 54, such order also contains a default clause in the case of non-compliance of the directions contained there. So, Miller, everything is being monitored by the Supreme Court, and in para 56, in view of the directions contained in the order of 17th April, it would be safe to infer that the Honorable Supreme Court is still in ceasing of non-compliance of the direction. Therefore, Miller, the Division Bench is also, Miller, is of the view that the Honorable Supreme Court is in ceasing over the matter. Therefore, Miller, assuming for argument's sake, Miller, that the writ petitioners, Miller, have a cause to, Miller, interject, Miller, the framing of the scheme or implementation of the scheme, Miller, my respectful submission is, Miller, when the Supreme Court is in ceasing over the matter, and, Miller, even going by, Miller, Article 144 of the Constitution, Miller, but as the Supreme Court said, Miller, in the judgment which I have handed up, Miller, the parties should, Miller, approach the Honorable Supreme Court. And waitlisted candidates were before the Supreme Court. It's not that they were strangers in the Supreme Court proceeding or before the High Court. Therefore, Miller, these are, Miller, primarily, Miller, my submissions, and, Miller, no argument has been made that the state is legislatively powerless to frame this scheme. Because 162 says that the executive powers extend to the extent of legislative powers. So no submission has been made that the state is powerless to legislate on this topic. Of course, it cannot be, because Article 41 has been referred to. Rightly or wrongly, it has been referred to, Miller. Therefore, Miller, in the absence of, Miller, any submission that the scheme or the legislation is ex facie unconstitutional. But in my very respectful submission, Miller, it doesn't call for, Miller, any interim order. Miller, provided, Miller, my points of demur are not accepted by the court. Therefore, Miller, in order to, Miller, pray for an interim order, Miller, one has to show that the legislation or the executive order is ex facie unconstitutional. But that no submission has been made. The submission is that Supreme Court order is sought to be bypassed. And when the Supreme Court has taken note of that in such a case, the Supreme Court is capable enough to take care of its order to be complied with or violated, or to act in aid or acting divorce aid of the Supreme Court. The Supreme Court will take care of that. And we have 2 more sentences, Miller. One is, Miller, a number of review applications are pending before the Honorable Supreme Court. And number 2 is, Miller, the scheme itself is, Miller, interim in nature. But may I place, Miller, those portions? Mr. Bhattacharya has placed those, but please have a look to, Miller, page 70. Please take the last recital at page 71. And whereas this scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families of non-teaching staff in Group C, Group D categories until the final adjudication of the review petitions. or appropriate application by the Honorable Supreme Court. Then, my lord, your lordship may kindly take, my lord, the page 72, paragraph 6 of the scheme. First is, my lord, an eligible non-teaching staff in Group C, Group D belonging to a distressed family shall be entitled to, etc., as livelihood support for his or her distressed family due to sudden unemployment and on humanitarian grounds with effect from so and so and whose salary has been discontinued. The benefit shall be discontinued upon occurrence of so and so, so and so. Any of the following, whichever is applicable or occurs earlier. Of which, my lord, item number I is, my lord, conclusion of the Supreme Court proceeding. Yes, and 5 is, my lord, on securing some other livelihood. Therefore, my lord, the scheme itself is, my lord, interim in nature. Scheme refers to the Supreme Court review petition. Scheme again says that it will come to an end once the Supreme Court takes a final call on the review applications or whatever are pending.
Tell me one thing.
Yes.
The amount has been fixed at rupees
20 and
25,000.
25, yes.
20 and 25,000.
Right.
How did you fix up this figure?
But I think it is for the C, it is.
So the salary amount you've taken as the base rate or something.
But on this, right now, I'm not in a position to assist you.
And how many candidates' jobs were set at naught by the order of the Supreme Court? Who will be the beneficiaries? The figure?
C and D.
And page 71,
Yes, ma'am.
the third recital
Yes, ma'am.
mentions about a similar incident in the past.
Yes.
What are such similar incidents in the past where the financial benefit has been granted
Well,
to?
there has been a lot of instances, may not be for relating to employment. To my knowledge, say for example, my lord, puja donations.
No. Those
Say
are
for
separate.
Yes,
Those
no.
are
But these
separate.
are because 282, my lord, the attention of the court has been drawn to 282. Therefore, my lord, I am saying, my lord, these are all, my lord, come, my lord, under different heads from the consolidated fund, and my lord, different separate account numbers are required to be, my lord, maintained. And there's another judgment where right now, my lord, I don't recall, where, my lord, our High Court has held in regard to the expenditure from the consolidated fund. It is not for a judicial review by a writ court. I'll get that judgment because I was possibly, my lord, addressing the division bench on that. In a PIL, my lord, that was held.
Regarding the
financial expenditure.
Honorarium granted to the
Very many
Muslim,
was there. Very
to the
many was there.
Muslim priests or something.
Yes, yes, yes.
There is
No.
one order,
Yes, yes.
right? But tell me, so you are not aware as to why this 25,000 has
20 and 25
and the assistance that you will be giving to these people, will these people give anything in return, or they'll sit at home and they'll earn the money?
My lord, here, my lord, because of, as the scheme says, because of sudden loss of livelihood.
That means somebody will stay at home and you will go on paying the money till the Supreme Court decides an issue.
But
And how long will the issue be said to be pending before a Supreme Court? Because one after another review petitions will come. There will be no end. You cannot stop anybody from filing a review application.
That is for, my lord, the Supreme Court to consider how long, my lord, Supreme Court will entertain.
And no,
Supreme Court will
your
not entertain
petition
me
says no. Your petition says it will continue till the matter is pending.
No, still, my lord, this review applications, my lord.
So one after another review applications will come.
No, my lord, please have a look to, my lord.
Second paragraph, filed review petitions before the Supreme Court. Central School Service Commission has filed review petition. Right.
No, it's only, my lord, the state government, the first recital. Please have a look at page 70.
Yes.
The state government, along with the School Service Commission, has filed respective review petitions before the Supreme Court.
Yes.
Yes. So it is only, my lord, the review applications which has been filed by the state and, my lord, commission, which is taken note of in this scheme.
No, but then what will be your submission with regard to paying 20 or 25,000 rupees to a whole lot of candidates who are sitting at home and not doing any work? Public, you are spending public money for it.
Yes. Yes.
And to candidates whom the Supreme Court has specifically
Well, not to
used
the prejudice
the-
of, may I say this? Yes, I got your lordship's point. My first response would be, my lord, that, my lord, at the instance of, my lord, the writ petitioners, my lord, with respect, my lord, kindly do not take me amiss. Possibly, my lord, this point cannot be raised by the petitioners. That if I am not getting, why is he getting?
No, he is not getting his waitlisted, no question of
Therefore, my
it.
lord, if he or the petitioners over here cannot get, then, my lord, the petitioners does not have a cause to pursue before this court.
So you want somebody who were there in the Supreme Court to come here and challenge this? Who could be the, according to you, the challengers to this
My
scheme?
lord, may I say this, my lord, today, my lord, we are concerned about the writ petitioners. But if the writ petitioners either have a right or they don't have a right. If they do not have a right, my lord, then whether tomorrow somebody will come or somebody comes at my liking is something different. If they do not have a right today, my lord, in my very respectful submission, my lord, this petition cannot be
Maintainable. All right.
entertained. Because, my lord, your lordships have held, my lord,
Yes, I follow.
mandamus is, my lord, for infringement
Anything
of an established right.
Anything in reply?
No, 1995. যেটা ও রিলাই করলো
99.
99 the deepest of respect, my learned advocate general, probably
The first demurrer was locus standi. It is not a pill, it's a writ petition.
this writ petition by a person who was a candidate. After cancellation of all appointment method, all persons come to the same footing. There you cannot make a classification. That's the first point, Milord, for a writ petitioner, which comes under Article 14. I am not, therefore, the locus standi petitioner, Milord, cannot be questioned at all.
Very well.
Secondly, one important aspect which you wanted to raise kindly takes up 1999 5 SCC. I have not cited judgment, but if necessary, there are judgments, I will cite it. But let me rely on his own judgment, which is relied upon. First of all, this has no 141 application. Kindly first,
144.
no, 1999 5 Supreme Court cases, page 733 does not decide any law which has binding nature to this court under Article 141. What does the court say? Let us see. May I just place it? Paragraph 4. We are rather concerned to note that the writ petition number such and such has been entertained by the Lucknow bench of the Allahabad High Court. That writ petition is directed, kindly see, against an auction sale of house number such and such, and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court has noticed in the interim order that auction was being conducted under the orders of this court, and the matter concerning auction of the house was pending in this court. Therefore, the question of amity of judicial discipline comes. In our case, this is a new cause of action. You prepare a scheme after the judgments have not become a concluded effect. Mere filing of review application does not legally entitle somebody to say that the
List is pending.
only after the review notices are issued, and the Lordship knows, as so from my experience, I can tell you, Lordship, the Supreme Court review applications are not hard. This is decided by the honorable judges in the
Chamber.
That's why they use this method of filing MA applications, and which have been repeatedly dismissed by the Supreme Court. That indicates the Supreme Court has reached its final conclusion. After that, this scheme, Article 162 does not empower you, I have argued this, to negate a judgment of the Supreme Court in any manner. The judgment declared by a court can only be changed by way of a legislation removing the foundation of the judgment. That is the settled principle. I don't have to argue. Even in this court, we had got the Cooperative Societies Act ultra vires declared. Then they passed a legislation taking out the grounds on which this was declarative ultra vires and passed another law, which is also under challenge. That's a different thing. Therefore, that is the settled law. Therefore, 162 does not empower you to legislate in the form of executive action to negate a Supreme Court judgment or even negate a High Court judgment. And this scheme is specifically maintained for the persons who have been found to be corruptly appointed. Can the state, in any form, giving in the name of relief, support corruption? This is the first question. The second question was that not only they have been found to be corrupted, this direction of the High Court, which is upheld by the Supreme Court, that they have to return the benefit of money which they have earned so long. And instead of getting the money returned from them, you are trying to support them out of public fund. This is the question of the constitutional morality again comes in. And in this context, Lord, I would like to cite one of the decision of the Supreme Court where the then Chief Minister of UP, Mr. Mayawati,
106. (106)
2012 8 SCC 106. Here, my lord, the CBI started an investigation saying that the Supreme Court directed. The petition was filed. From that, it went up to the Supreme Court. Supreme Court says entire thing is quashed. Because you cannot take, in the name of Supreme Court, start doing something which is not under the order of the Supreme Court. This is the basic principle of this judgment. I just kindly place before Lordship the relevant portions.
Citation
2000 और लिखे रहते बोल का 2012 SCC page 106. After discussing everything in detail, now the Supreme Court says 41, kindly come to paragraph 41. We finally conclude that anything beyond the Taj Corridor matter was not the subject matter of reference before the Taj Corridor bench. That is the Supreme Court bench. Since the order dated 18 September 2003 does not contain any specific direction regarding lodging of FIR in the matter of disproportionate assets case against the petitioner, CBI is not justified in proceeding with FIR number so and so. In view of the above discussions, we are satisfied that CBI exceeded its jurisdiction in lodging an FIR in absence of any direction from this court in the order dated so and so or in any subsequent orders. And then ultimately squashed. Here, my lord, I have been facing repeated orders of the Supreme Court saying, no, we are not interfering 3rd April. And by repeated application, as it is also mentioned in the scheme, the review applications filed by the SSC and in future it might be filed. You are adopting very unfortunate tactics to waste public fund to protect the corrupt people. That everybody has jurisdiction, and because the writ court, where the fairness of the administrative action, Article 14 is very important.
Page 71.
71, kindly turn to page 71. And my lord has noticed it, that's why he was referring to it.
And whereas second last and whereas.
And page 70, and whereas the scheme aims to provide interim relief by of livelihood support and social security. Livelihood support, social security under Article 41 does not remain to a particular group. On humanitarian grounds, to the aforesaid distressed families of non-teaching staff in Group C and Group D categories until the final adjudication of the review petition and appropriate application filed before the Supreme Court or any other further petition has been filed. Twice attempt was made. And again will I say, there is no review application pending for consideration. Mere filing with the registry does not, my lord, entail consideration by the court. In that background, my lord, I would logically stay the entire scheme.
এটা একবার দেখি এটা একবার আমার কি মত?
সেটা বলে দিলাম তো।
একবার দেখি jurisdiction
You know, my juniors insisting me just to point out to your lordship paragraph 9
Of
of the petition, how my lord his locus is maintained.
sub
এই তো আর কিছু মনে রয়েছে। তারপর জয় জয় কালী। এটা আমি দেখাতে চাইছিলাম না। এটা আমার লোকাস তো বলে দিলাম তো তারপরে কোন দেখাবো।
very well.
But only one factual correction, because in reply, I am not supposed to say anything. My lord, the submission made by Mr. Bhattacharya that they have to return the salary, but that is, my lord, factually not correct. Kindly have a look to page para 46, page 60,
বলা ছিল। আচ্ছা বলা
45 and 46.
তুই মিস করেছিস।
টেন্টেড যারা তারা দেবেন যারা
However, my lord, candidates who are already employed need not be asked to refund.
These are for the teachers. The scheme is for non-teaching staff.
না না স্যার এটা বলে দিন
ফটফট করতে
46 does not, my lord, make any distinction between the group C, group D and teachers.
স্যার নট
আরে খোঁজকে পড়তে দাও না, এত ছটফট করো কেন?
Those who are already employed need not be asked to refund.
Yes.
Right.
Yes.
So you are not giving money to the candidates who are already employed. You are giving money to the candidates who have been terminated.
No, no. But my submission is, Mr. Bhattacharya in reply submitted that
Yes.
Supreme Court
Refund.
had directed refund.
Yes.
That, my lord,
But paragraph 45 says
no.
অল্প
they should be required to refund any salaries received. Then
But 46, my lord, does not make any distinction between the C, D, or my lord teachers.
please.
Very well, very well. You are not.
Whatever the Supreme Court has said, the Supreme Court has said in the
Right.
order. Whatever.
But one more thing, my lord.
Yes.
Mr. Bhattacharya submitted that filing of a review application does not mean that the Supreme Court is
In CC of the matter.
number one. My lord, the division bench has said that the Supreme Court is in CC over the matter.
Yes, yes, you've
And number two,
submitted
my
that.
lord, there is a judgment of Justice Rumapal. My lord, I don't remember, the page was 555. That's why I remember the page number. Where, my lord, in the context of a contempt application, my lord, our court held that once something is filed in the department, the court or the matter becomes sub judice before the court. Then, my lord, the court may allow it, may dismiss it, whatever it is. But my lord, once it is filed in the department, the matter becomes sub judice. If required, I can give that
No,
judgment.
that
But over here, my lord, our division bench in the context of this matter has said that
that
it was in
is correct. That was in respect of limitation of contempt application. That since it is filed, limitation will not run.
Yes, but so yes,
তো ওইটা ঠিক বলেছো, লিমিটেশন ছিল কন্টেম্পটে 1 বছরের মধ্যে অর্ডার ছিল বলে ফাইল করলে পরে ধরে।
and my lord, salary possibly, my lord,
Anyway,
the salary amount was much higher, my lord, I am told, than my lord 20,000 or 25,000.
that is
So
basic.
these people will be receiving either 20 or 25 sitting at home.
Basic.
With
Sitting at home.
if tomorrow, my lord, the Supreme Court dismisses the review application, matter ends over there.
Till the Supreme Court dismisses, the persons
that
will
is
be
not-
paid.
That is expressed in the, my lord, the
Scheme itself.
scheme itself. I cannot, my lord, make any submission contrary to that.
Told you.
And whether similar type of schemes are extended or thought of by the state in respect of so many unemployed candidates?
No. The, my lord,
Only in respect of the
the
candidates
unemployed,
orders
yes.
whose appointments have been set at
The
not by
Supreme
the.
Court,
Very well.
Supreme Court can take care of that, my lord.
No, no, you are the state. You will take care. Supreme Court is not
But, my
framing
lord,
the
when,
scheme.
my lord, I have raised, my lord, a legal issue that when it is, my lord, concerning the Supreme Court and in response to the
Yes,
submission
yes, I followed it.
that the Supreme Court's order is being subverted, but my submission is, my lord, it has to go before the Supreme Court.
6 বছর হয়ে গেছে।
Hearing concluded, CAV.
I'm grateful. That's all.
Affidavit of service is taken on record.
সবাই এটা আমি দেখাবো।
Sorry.
আমি তো হবে না। আমি আর
Similar matter. What the similar matter is filed